Hey team, here's your roundup of this week's immigration updates and shows that we did on our Spanish radio stations, and we're giving it to you here in newsletter format with an English video summary so those of you who prefer to speak in English can keep up with what's happening. Our first show was about petitioning for parents. Everybody knows who, is within the realm of immigration that once a U.S. citizen child turns 21, they can petition for their parents. That's pretty common knowledge. What a lot of people don't know is the ins and outs of what that looks like, and the fact that many parents are actually ineligible to get legal status from their child even after they turn 21. The reason for that is that when someone enters without a visa and their child turns 21, the typical way to gain permanent resident status or a green card is through the consular process. That's what's required when you enter without a visa. And the consular process is a multi-phase process, and one of the requirements is a waiver for unlawful presence. The problem is that the waiver can't be based on a child. So even though the 21-year-old kid, can be the petitioner, if the parent enter without a visa, they can't get a waiver. So this is a very common conversation that we have to have with people. It's not a fun one, who have been waiting years and years and years, 2 decades, for their child to finally become 21 because they know that that's when their kid can petition for them. And then they come to us and they find out because they entered without a visa, they don't have a qualifying relative for the waiver, we can't actually get them permanent resident status. So it's really important to understand how this works. There are 4 main ways that parents can get immigration status through their 21-year-old child. The first is if they entered with a visa. Maybe they had a tourist visa, maybe they had an employment visa, maybe they had a student visa. And if they entered legally, and now even if they overstayed, their child is 21 and they don't have other complicating factors or grounds of inadmissibility like criminal records, multiple entries and exits with unlawful presence, etc. But if they just entered and it's clean and they entered with a visa, their kid's 21, now we can do what's called a one-step, an adjustment of status and petition for the parent without needing a waiver. Another way is called parole in place, and that's if the child has served in the armed forces, the U.S. Armed Forces, which Coast Guard, Marines, Air Force, Army, Navy, Secret Service, and if they are still serving or they've been honorably discharged, they can apply for parole for the parent, which essentially gives the parent like a legal entry, and then they can adjust status. So that's if the child has served in the armed forces. The third, and a pretty common way for us actually, is VAWA, the Violence Against Women Act, which isn't just to protect women, but if the parent has suffered cruelty from their child after the kid is 21, then the parent can apply even if they entered without a visa. And so cruelty can be a lot of things. It doesn't have to be physical violence. You don't need a police report. It can be controlling, manipulative, verbal abuse, behavior, emotional abuse. There's lots of ways that a child can be abusive to a parent that don't involve physical violence. So it's worth exploring. And if the child is a U.S. citizen, it's not going to hurt them for their parent to file a VAWA case because they can't have their status taken away. And you're not filing a police report when you do a VAWA case. The fourth way is something called 245I. That's an old amnesty style program that says that anyone who was petitioned in the United States before April 30th of 2001 by an employer or a relative, and even if they entered without a visa, they can now adjust status. So it's a type of amnesty that parents can utilize. And so the best thing to do is consult with us if you have any questions about this, because we have creative ways to make these cases work. Like maybe dad entered with a visa, but mom didn't. We can adjust dad's status to permanent resident, and then mom will have the qualifying relative, a husband with a green card, that she needs for the waiver. So there's ways to work around it. Best thing to do is not talk to your neighbors, your friends and family, compare your case to anybody else, because no case is alike, no case is equal. Just come and talk to us and we'll walk you through it.